She was trusted by the school district and by parents. But tonight, a fifth grade teacher in Cape May Courthouse is accused of having a sexual relationship with one of her students.
For years and had his baby.
Do you know Miss Karen? There's nothing to see here. There's no one that wants to speak with you.
This unidentified man pulled up to the home while we were there. A short time later, another woman appeared from the home after we'd already left.
Do you want to talk to us?
No, I want you to see.
You came outside, please. I'm willing to talk to you.
His brother began spending time at the defendant's residence, starting with 1 to 2 nights a week, which progressed to staying there permanently. The victim indicated that he would sleep at Karen's residence and that he and his brother would sleep on the second floor. The victim confirmed that he has a relationship with the defendant and believed that he would have her twice a week. He also confirmed that he is the father of FC. He also stated he continued to have communication with Karen. The defendant, up until his father made the Facebook post that brought all of this to the attention of the police.
Alright, what's up with it, y'all? So look, man, I'm back again with another video. And listen, man, I got a crazy situation to talk about today, and I'm pretty sure a lot of y'all have seen the story, but really don't have a lot of context. And me personally, if you've been rocking with the channel, y'all already know I'll wait a couple of days with a lot of different stories just to make sure that we are talking about the right things correctly and stuff like that. I hate jumping on something just because it's trending at the time, you feel me? But anyway it go, we finna break everything down and watch everything that's been taking place with this whole case so far. And it's just so crazy, sad, and unfortunate that the justice system lets people down consistently, but we already know how they go. And before we move forward into the video, I want to tell everybody out there, I appreciate y'all for being here. I hope that everything is okay with you and your family, and I'm wishing y'all nothing but the best in every aspect of your life, and I'm sending y'all nothing but peace, blessings, and prosperous energy our way. And yeah, man, when I say that, I'm strictly talking to those who reciprocate the same energy back to me, and to those who say the same thing back to me in the comment section. Also, make sure y'all add my Facebook, Snapchat, Instagram, second and third, fourth YouTube channel. All that's gonna be in the comment section as well. And make sure y'all hit that like button too if you're a supporter of the channel. That way I can stay connected with me and don't be losing me. You know what I'm saying? When I post these videos, y'all get notifications 4 or 5 days later and all of that. Other than that, let's get straight into this right here. So this crazy, weird, funky fucker by the name of Laura Karen, she done got pregnant by one of her students, allegedly. Well, a 5th grade student, right? Now, she done had the baby and everything, and it's just so sad and unfortunate that the parents actually gave the children to her to basically be a caretaker and watch the children for a lengthy period of time. Now, allegedly, she's been messing with this little boy since 2016, if I'm not mistaken, and it allegedly ended in 2020. But y'all already know right now it's 2025, right? And allegedly, the baby that she did have is 5 years old, and it's supposed to be his. Now, there's so many things that took place, and I got the court video at the end where she's in court, and can you believe that the judge let her free for right now? Now, I can understand the, points that her lawyer was making, because they basically just arrested her off of accusations, right? The father put a post on Facebook saying that the baby looked just like him and the son, right? And that sparked some confusion somewhere, and it sparked an investigation immediately afterwards, right? So they ended up researching and figuring out that they've been messing around for a long time, allegedly. Now, the brothers and sisters and other people that was around them actually said that they witnessed certain things, and they were kind of confused by certain things that was taking place in the household. I'm gonna let y'all watch all of that in the court videos, but when you hear what they saying, you'll be like, what the hell? And allegedly they said it was 400 and something occurrences that took place between the two. Now, me personally, I don't understand how people be on here, and a lot of people be making jokes about dealing with little boys now, and it's just so crazy to me. They be saying they want a young dude, a YN, y'all know what that is, a young nigga, whatever the case may be. I just feel like that it's okay if you got your preferences and stuff like that, but it's a certain age limit. I feel like you shouldn't even be attracted to somebody. Their mindset not there. Nothing about them should be appealing to you until they can actually be fully developed, in my personal opinion. But I digress. People gonna do what the hell they want to do. But this crazy fucker right here ended up getting out on bond, and it's just crazy to me. They got so much substantial evidence and circumstantial evidence to the point where it's like, how the hell is she free? But the lawyer is basically stating that Y'all are basically going off of word of mouth versus DNA evidence. So right now, they're waiting on a paternity test that could possibly take months to get back. And I feel like, with all of the evidence that they got and the testimonies that they do have right now, it shouldn't be no letting free right now. Because if it was a dude, you better believe he'll be up under the jail 10,000 feet, But hey, I'm going to go ahead and let everybody watch this right here. And then we're going to talk about certain things in between time. I just have to give y'all a little brief update and let some people who at work right now know what the hell going on, who can't watch the full court video until later on. But let's get into it.
She was trusted by the school district and by parents, but tonight a fifth grade teacher in Cape May Courthouse is accused of having a sexual relationship with one of her students. Detectives say the started when the child was 11 and lasted for years, and that the two share a child. Wednesday night, I'm Shari Williams. Rick has the night off. The big story on Action News tonight is a South Jersey teacher behind bars accused of a young boy and having a child with him. Action News reporter Leland Pender has the story from Cape May County, and detectives say the investigation is far from over.
Middle Township Police and the Cape May County Prosecutor's Office both investigating here. Prosecutors say these alleged crimes occurred between 2016 and 2020, but the arrests just coming Wednesday. They're now asking anyone that might have even more information to please come forward. Once a fifth grade teacher, now behind bars with bond revoked. 34-year-old Laura Karen was taken into custody at a home on Orbit Drive Wednesday in Cape May Courthouse. Prosecutors allege she's a former student for several years and had his baby.
Do you know Miss Karen? There's nothing to see here. There's no one that wants to speak with you.
This unidentified man pulled up to the home while we were there. A short time later, another woman appeared from the home after we'd already left.
Do you want to talk to us?
No, I went to
You came outside. Please, I'm willing to talk to you.
Authorities say began when the victim was 11 years old. According to the criminal complaint, a few years later, Karen gave birth to the victim's baby. Karen taught at Middle Township Elementary No. 2, and the victim was once her student. Prosecutors say Karen and the victim's family became friends, leading to the victim and his siblings staying overnight with Karen once or twice a week, but at some point they began living with Karen permanently. Investigators say the case came to light last month when the victim's father posted on social media saying Karen's 5-year-old child looked very similar to him and his son. Neighbors say the arrest Wednesday appeared discreet. This woman said she saw multiple black SUVs but didn't realize they were police.
If it's true, I feel sorry for the people.
According to the prosecutor's office, the school district will have support services and counselors available for students, teachers, or families who may need that in light of this news. We did reach out to the school district for comment but did not hear back. Here in the community at Cape May Courthouse, Leland Pender, Channel 6, Action News.
A former South Jersey teacher accused of having a relationship with a teenage student appeared in court today. A judge ruled that 34-year-old Laura Karen be released from jail as her case proceeds. Karen was a fifth grade teacher at a Middle Township Elementary School. She's accused of assaulting the victim inside her home from 2016 to 2020, beginning when that child was 11 years old. The victim was 13 when their child was born in 2019. She was arrested back on December 17th.
Judge, we can mark for the parent.
Now, I don't know why the hell they gave the children to her to let them, watch them permanently or whatever the case may be. Now, some of the things will be brought up in this court hearing right here, but I do want to say the judge's part, you really cannot hear him too well, so you got to be really paying attention to it. But I want y'all to hear the argument points on both sides and let me know your thoughts and opinions. I feel like with all of this evidence that's been presented, she should definitely be in jail. But there's so many things that go into certain things, so it is what it is. But hey, let me know your thoughts and opinions on everything. And I'm going to talk about my hands. But yeah, I'm going to talk to y'all a little bit later on another video.
17th.
Judge, we can mark for the parent's way. I had a chance to talk to Laura a number of times before today. She understands the charges, understands the rights. We'll walk through the parents and your plea man right now. This hearing will stipulate the probable cause. We're limited to today's hearing alone and stipulate. understanding, even though this particular problem was.
Thank you, Judge. It's the state's position that there's no amount of monetary bail, non-monetary conditions, or a combination of the two that would reasonably assure the defendant's appearance in court when required, the protection of the safety of any other person or the community, and that the defendant will not obstruct or attempt to obstruct the criminal justice process. Turning to the factors as to the nature and circumstances of the offense charged, as to the probable cause, on December 12, 2024, Middle Township School Superintendent Dr. Salvo reported to Officer Runyon of the Middle Township Police Department that he received an anonymous tip that a teacher may have had a relationship with a student. The teacher was identified as this defendant, Laura Karen. This came from a Facebook post made by the student's father on 12/12/2024 that indicated that the defendant's 5-year-old child, SC, looks very, very similar to him and his son, JM Jr. The defendant is a 5th grade teacher at Middle Township Elementary School number 2. That day, police conducted an interview with the victim's father, and he indicated that the defendant taught both of his sons, the victim and JM, in 5th grade. Over the years, he and his wife became friends with the defendant, and they began to let their children stay at her residence, and she would take them to school. The father explained that it began with 1 or 2 nights a week, and eventually the children stayed with the defendant permanently in her Cape May courthouse home from 2016 to 2020. On December 16, 2024, the victim's sister explained to police that she spent time at the defendant's residence and believed the victim was 11 when he started sleeping at the defendant's residence. The sister explained that the children would sleep in a shared bedroom on the 2nd floor, but noticed the victim would not be in his bed the following morning and would be sleeping in bed with the defendant. The sister stated that the victim would shower in the 1st floor bathroom while the other children would shower in the 2nd floor bathroom. The sister also noticed that when the victim would shower, the defendant would enter the bathroom and lock the door. The sister also provided a screenshot of a text conversation she had with the victim, where he admits that he is in fact the father of this defendant's 5-year-old child, and requests her not to tell anyone because he does not want to get her in trouble. That same day, police obtained a statement from the mother of the victim, who explained that she met the defendant when she was her children's 5th grade teacher and began to have a friendship with the defendant. And with that, the defendant would offer to watch her children, which eventually progressed into her sons living with the defendant full-time at her home. Following the Facebook post, the victim's mother had a telephone conversation with the victim. He confirmed that he is in fact the father of SC. 2 days later, police obtained a statement from the victim's younger brother, who indicated that he and the victim started staying at the defendant's when he was 8. Shortly after living there, he noticed the victim would not sleep in his bed on the 2nd floor, and he would observe the victim sleeping in the defendant's bed. He observed the victim and defendant exiting the 1st floor bathroom together, both wearing towels, both wet. The brother indicated that one night, while watching a movie on the 2nd floor of the residence, the defendant and the victim believed that the brother was asleep. The brother stated he was laying in his bed, and the defendant and victim were on a reclining chair with a blanket over them, and he saw the defendant, the victim. The victim was 11 at the time. Following the birth of SC, the brother indicated the victim permanently slept in this defendant's room and would also keep clothing in her dresser. Following the Facebook post, the brother stated he spoke with the victim via phone, and he indicated that he in fact is the father of 5-year-old SC. During interviews with the victim's family, it was found the defendant would purchase the victim gifts. SC was born in April of 2019, which is when the victim was living at the defendant's residence, and he was 13 years old. This defendant at that time was 28 years old. On January 3rd, 2025, police obtained a statement from the victim. He explained that the defendant was his 5th grade teacher, and after completing the 5th grade, his family became friendly with the defendant. He explained that he and his brother began spending time at the defendant's residence, starting with 1 to 2 nights a week, which progressed to staying there permanently. The victim indicated that he would sleep at Karen's residence and that he and his brother would sleep on the 2nd floor. The victim confirmed that he had a relationship with the defendant and believed that he would have her twice a week. He also confirmed that he is the father of SC. He also stated he continued to have communication with Karen. The defendant, up until his father made the Facebook post that brought all of this to the attention of the police. Turning to the factors as to the nature and circumstances of the offense charge, this defendant is charged with some of the most severe offenses under our laws and involve fundamental breach of trust and personal boundaries. As to the weight of the evidence against this defendant, there are the statements of witnesses. The nature and seriousness of the danger to any other person or the community that would be posed by the defendant's release. This defendant's actions represent a gross violation of the trust placed on her as an educator and as a caretaker. As to the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process, there is, of course, a potential for witness intimidation. The release recommendation of the PSA is a no release recommended, as this is a NERA offense. The defendant engaged in a sexual relationship with a minor who was in her care and living under her roof from 2016 to 2020, while the victim was between the ages of 11 and 15. At that time, this defendant was employed as a teacher, occupying a position of authority, mentorship, and trust in the life of that child. These charges involve egregious conduct, the repeated exploitation of a minor over the course of several years. Aggravated assault, the top charge for Ms. Karen, is a first-degree offense, carrying the presumption of incarceration upon conviction. Additionally, the defendant's actions include grooming and abuse of her position of trust, which exacerbates the severity of these crimes. The prolonged nature of this abuse demonstrates a calculated effort to manipulate and control the victim, including contacting the victim up and until the Facebook post in this December. An additional 4 years of contact and manipulation with this victim. This defendant violated not only the law, but also her professional duties to safeguard the well-being of children. As noted during the statement of probable cause, the victim indicated that the assault occurred 2 times a week for 4 years. That would be 416 separate assaults this defendant committed against a child. As to the risk of flight, given the serious nature of these charges and the substantial penalties associated with the conviction, the defendant has a significant incentive to flee. The conviction for aggravated sexual assault carries with it a potential prison sentence of up to 20 years, subject to the No Early Release Act, requiring her to serve 85% of the sentence before parole eligibility, as well as Megan's law and parole supervision delay. The defendant's ties to the community, while notable, are insufficient to mitigate this risk. Her employment as a teacher is over because of these charges, and her community connections may be irreparably damaged in light of these innocent allegations. As to the danger to the community, this defendant poses a danger to the community, particularly to vulnerable populations such as children. As an educator, this defendant has demonstrated an ability to exploit her position to gain access and manipulate minors for her own gain, for her own gratification. The victim was subjected to years of abuse, and there's a risk of harm to other potential victims if this defendant is released. I'm also going to emphasize the psychological harm she inflicted upon this victim, whose trust was betrayed in a devastating manner. He became a father at 13 years old. The defendant's predatory behavior highlights the need to protect the public from any kind of future harm. The state submits that there's no combination of conditions to reasonably assure the safety of the community, ensure her appearance at trial, or guard against obstruction. Her actions represent a gross violation of the trust that was placed in her as an educator and a caretaker of this child. State maintains pretrial detention is not only justified but necessary to protect the triad, and I would ask that Your Honor follow the recommendation of the PSA and detain this defendant pretrial. Thank you.
Your Honor, thank you. Judge, in the state's moving papers for detention, the state mentions nothing about the potential for obstruction, nothing about any evidence of obstructing in any way, shape, or form. I can indicate to Your Honor, Laura was suspended on December 17th, a couple weeks before she got arrested. And there's no evidence put forth today by the state to indicate that she ever reached out to the family, to the alleged victim, or any witnesses in this case. None whatsoever. So not only does the state not mention any evidence of obstructing, the state's argument is there's a potential for obstruction, which is about as weak, I think, as you get, Your Honor. So my argument number one, on that part of the triad, there is no evidence whatsoever that Laura did anything, since she became aware of the disclosure in this case, to try to contact the victim or his family to do anything that could be construed as interfering or obstructing the process. I think that's important. Judge, you know from the PSA, Laura is 34 years old. Her background is spotless. Absolutely spotless. Grew up in Bucks County. Your Honor, four siblings in her family, a good, wholesome family upbringing. Warrington, Bucks County. Graduated from Archbishop Wood. Went to Cabrini College. Played varsity basketball for Cabrini at Division III school. All 4 years, excelled in academics and excelled in sports as well. And her major was education. She got a job down here. She's been a 5th grade elementary school teacher at Middle School District for the last 11 years. Her background as a teacher is impeccable. Not one complaint, not one anything, other than high praise for the type of person that people know her to be, especially in the education community. Not one thing put forth by the state to suggest that there is anything about her background that would bespeak of anything other than a flawless background and a very impressive young woman. Now, that does not address the facts put forth by the state, of course. But, Judge, although the facts are relevant and the strength of the state's proofs, the state did something in this case. They made a conscious decision to make arrest before there was any DNA investigative work done in this case. So now after Laura has been arrested, and only after the arrest, they get search warrants for her DNA. They got the victim's DNA voluntarily from him, and they have a search warrant for my client's 5-year-old daughter for her DNA, and that will take months for that evidence to be that biological evidence to be obtained, sent to the lab, and processed. And Judge, we think that the DNA evidence is really going to tell the tale in this case. But what's missing from the state's case right now, notwithstanding the state's argument to the judge, to the court, there is no DNA, no medical evidence, no physical evidence, no microscopic evidence, no fibers, no nothing to back up the allegations made. I mention that because as the court considers the strength of the state's proofs, although they're certainly not rock solid because they don't have that DNA. They could have waited. They could have completed the investigative work in this case before arresting Laura. They chose not to do it, and they come into court and argue that this is a rock solid case. Without the DNA, Your Honor, I suggest it's not quite as strong as the state may proffer today. Your Honor, the risk of flight, she has nowhere to go. She lives with her mother. The house at 25 Orbit Drive in Cape May Courthouse, she lives with her mother. Her mother was there the entire time that the children were at the house. Full time. It's her and her mother. The deeds in her mother's name. Her father and brother are in court today. Her father still lives in Bucks County. Judge, if she wanted to take off and become a fugitive, she wouldn't have the slightest idea, wouldn't have the willpower or the ability to do that. I think, Your Honor, that's why the one for a risk of flight is an accurate risk assessment there. Also, the risk of committing a new crime. Whatever happened in this case, that will be flushed out down the road. Judge, what you do know, not even a tiny bit of contact with law enforcement in 34 years. No trouble in school, no trouble in college, no trouble post-college, no contacts whatsoever. So the score of 1 on a risk to reoffend, if Your Honor allows her to go home, we think the PSA got that right as well with a 1. The lowest scores that she could possibly have. So, Judge, if there's really not a realistic risk of flight, and there's really not a realistic risk that she will commit a crime if Your Honor lets her go home, there's no real risk of obstruction, or there would have been some evidence of that before today. So the only real risk before the court that really has any substance to it would be if she reached out to the victim or his family if released by the court today. And Judge, a no contact provision. I talked to Laura about that. I talked to her last week. We talked again downstairs. She is absolutely aware if Your Honor released her, she would not be allowed to have any contact with the victim or his family. And Judge, she will abide by that. She will abide by whatever conditions or whatever level of release you could deem appropriate. But if she's kept in jail, she can't get that time back. She will never be able to get that time back again. If Your Honor releases her, and if the state's proofs develop along the way, they can get their time out of her. She's not going to go anywhere, but she will not be able to get any part of her life back if she's required to remain in jail. Judge, there was a case that the court presided over not too long ago out of Ocean City. And I know Your Honor is very much familiar with that case. I won't mention the name, but it was out of Ocean City. It was a case that I handled, and Your Honor made a tough call at a detention hearing on a 42-year-old man who had his father's background, was a school teacher, and had a first-degree aggravated assault. His scores on the PSA were a 1-1. with recommendation for no release. We had a very long argument, both sides before the court. Your Honor took a chance on him. Your Honor released him with strict conditions. He complied with every single condition that Your Honor imposed. Months and months had gone by, a lot of pretrial litigation. Case was on the trial list and it netted out to a probationary sentence. Notwithstanding that the state argued a lot of the same words that came out of the prosecutor's mouth today. Judge, I think the similarities are there in that case because it's really a state versus Mercedes notation on the PSA, even though she's a 1-1, she's a 1-1, and we know there's no evidence of obstruction and no new violent criminal activity flagged. The PSA indicates just because of the nature of the crime that the recommendation is for no release. So I think it's similar. I believe that if Your Honor takes a chance on Laura, she will not disappoint the court, and the state will move along with their investigative work, but she will comply with any condition the court imposes. Judge, there's an issue with her child in the house. We understand that DCP&P has given custody to her mother. Whenever DCP&P orders would be in place, she would know she would have to comply with that. She has a grandmother, an 89-year-old grandmother that lives right next door to her and her mother, that Laura is actually the caretaker for. So arrangements can be made for her to live somewhere else if the DCP&P order required that. But Judge, we respectfully ask that the court consider the very, very low, unrealistic risk of flight, risk of committing a new offense, and risk of obstruction. Thank you, Rob.
What else can I say?
That's it, Judge. Thank you.
With regard to this matter, I'll make some general observations first. I've had the opportunity to review the submissions from the state, including what is arguably a more detailed version of an affidavit of probable cause than we normally have. I'll note for the record Mr. Thomas' reference essentially to the lack of the DNA and the state's decision to go forward without it. The court doesn't take any issue with that. The court, in this matter, just like every other matter, especially those that are presented before the court for detention, will base it on what's before the court at this time without speculation of what would happen in the future. Ms. Karen is a 1-1. She's a 1 on risk of failure to appear, 1 on risk of new criminal activity with a recommendation of no release based on the first-degree charge that was referenced by the state. She's 34 years old. This is classified as a violent offense, but does not trigger the new violent criminal activity flag. As the state essentially recognizes, and Mr. Thomas points out, Ms. Karen has no criminal history whatsoever. So when determining before the court whether there's a sufficient amount of evidence stated otherwise, whether the state is an expert in by clear and convincing evidence, that Ms. Karen's detention is necessary based on the factors and considerations of what we're going to make with regard to the trial. That she'll appear in court will require that the safety of the community and any particular victim is protected, and she will not obstruct or attempt to obstruct the criminal justice process. The court takes into consideration the lack of any criminal history. Bail reform essentially requires the court to look at these cases individually and make a determination whether the state has met its burden as to any of those 3 problems. Here we have obviously very troubling and reprehensible allegations with regard to the conduct that took place over a substantial period of time, as the state alleges. And with that, the court notes that in terms of viewing everything by virtue of whether the state is met its burden by clear and convincing evidence, looking at whether the defendant will appear in court require other than the nature of the charges themselves, which are significant, and the court does take into consideration the state's argument with regard to potential flight, with the absence of a criminal history either before or after this time frame of allegations, which is essentially 2016 to 2020. The court doesn't really have any evidence before it where I can find by clear and convincing evidence that the state has met its burden, that there is likelihood or by clearing things together, she will not appear in court when required, other than the nature of the charges and the potential penalty, which the court in this instance does not find is sufficient to at least meet that clear and convincing standard. With regard to the criminal history, the protection and safety of the community, the court takes into consideration that we have no criminal history that's either as a juvenile, as an adult, or no domestic violence history, which the court sometimes takes into consideration, even if there are no criminal charges. So we have no pending charges at the time of the offense. We have no prior DP or indictable convictions. We have no prior violent convictions, and obviously there's no criminal history at all. When taking into consideration the nature and seriousness of the charges, I don't want to discount the nature and seriousness of those charges, or the allegations, or the vulnerability of any victim. That's part of the allegations. Here we have charges that are essentially specific to a set of time from 2016 to 2020 that are particular to a circumstance, where for reasons that aren't entirely clear to the court, these children in this particular victim were living in a defense. I understand the chronology. Essentially, they started out once or twice a week and then became full-time. It's unclear to the court as to what else was going on with regard to either the parents' home or the children themselves that led to them remaining in his parents' home full-time. But the court does note that the allegations here are specific to that time frame and specific to this one particular victim. And again, I don't want my comments to suggest that I'm discounting the severity of the allegations as well as the vulnerability of the victim based on his age, as the state alleges. But there's a window of time here which the court has to review evidentially to determine whether presently Ms. Karen is a sufficient risk to the community as a whole for this particular victim. And the court finds here that there's no present danger to this particular victim who is now, for the most part, residing elsewhere. And he's an adult. I understand there is continuing contact, but there hasn't been anything suggested to the court with regard to obstruction, which I'll get to in just a moment. So while this defendant is a 1-1 with no criminal history, either as an adult or as a juvenile with DV history, and other than the first-degree nature of the charge, there's really no evidence with regard to failing to appear in court when required. The defendant is obviously local and has no criminal history that would allow the court to find by defendant evidence that she is a flight risk. There isn't any evidence of obstruction before the court as it's been presented to the court. The court doesn't have any, other than, again, Ms. Kelly's representations that there has been contact between the victim and the defendant. There isn't evidence before the court that would, one, establish that there's even an allegation of obstructive behavior with either the victim or the family, or any evidence that the court would use to find by clear and convincing evidence that there is obstruction or potential for obstruction. And the court, when viewing all of these questions, has to determine, one, in the context of Mercedes, as Mr. Tolan indicated, is that the scoring and the release recommendation of the PSA is one factor in the court's overall analysis as to all the factors which the court has already addressed and will address further in a few moments as to whether that's in and of itself a sufficient basis for detention. But when viewed in light of the other circumstances and evidence, the court has to make that determination, viewing all factors with Mercedes and its rationale being one overall, or one of the factors that the court considers overall. Here we have the absence of any obstruction. We have allegations that are limited to a time frame with no allegations or evidence that the court can use to find by clear and convincing evidence that there is criminality that either pre-exists this time frame with regard to the charges or postdates the time frame with regard to these particular charges. In light of that, and in considering whether there are less restrictive means that are available to the court short of detention, that would protect the safety of the community, this particular victim, that would ensure us that parents appear in court required and consider whether she will obstruct or attempt to obstruct the judicial process. The court finds that less restrictive means are available and will deny the state's motion for detention. Having said that, there are considerable restrictions that I want to put in place with regard to Ms. Karen's release that go specifically to the allegations, including, first and foremost, the mental health evaluation and complying with any and all recommendations that come out of that evaluation. Ms. Karen will be released on level 3 monitoring, and the court will also have no contact with this victim, no contact with the victim's family, obviously no contact with any potential witnesses. Ms. Paley, trust the state can provide this to Mr. Tonley and to the court as to who we can include on that order to make sure that there is compliance going forward. There's already a DCPP investigation that is ongoing. The court notes that just as they, the court will leave the parameters of what the DCPP investigates to their expertise and simply require that Ms. Karen comply with whatever existing orders are in place for Tonley and any orders that might come to be in existence as this case proceeds, which may include the residency issue that you alluded to. We'll come back to that in just a moment because I want to give the states a chance to weigh in on that. I'm also going to order as a general condition that separate apart from whatever compliance she has with her ability to see her own child, that's separate apart from that she's not going to have any contact with minor children. And obviously she's not going to be back in school, she's not going to be teaching. I think no contact with the school system as well is an important component for the court to consider, unless it has to do with some sort of ongoing legal process. Obviously, if there's something that's going on with regard to her review or suspension or anything else that might be required going forward, the court will make that exception. That's even an issue. Ms. Paley, while the court is denying the state's motion, I will give the state an opportunity to see if it wants to request any additional restrictions over and above what the court just mentioned, or is there any specific request from the state with regard to residency. The state probably has a better idea than the court what's going on with DCPP.
No, Judge, I think Your Honor covered everything.
And Ms. Paley, I'll leave open the ability for the state to revisit that in the event that there's something that changes with the DCPP order as the case goes forward. If you're of the opinion that the release order from this court and whatever family orders are in place aren't adequately addressing the state's concerns with regard to the protection of that particular minor or anything else that might be considered relevant to this case. Ms. Karen has the next court date with a pre-indictment conference in February 18th. Should we require a schedule for the period for court at that time? I'm going to go through, sorry.
Judge, with respect to the...
Is that not consistent with your week?
I don't believe so, Judge.
You're right, it's not. So let's use February 25th.
Thank you, Judge.
Thank you for the reminder. So it will be consistent with Ms. Paley's weeks going forward. I'm going to go through the order as a whole now to make sure that there aren't any conditions or findings that the court hasn't addressed specifically as it relates to this. The court, in denying the state's motion, orders Ms. Karen to appear for the February 25th court date as well as on all others. And that includes family court appearances as well. And must be notified by pretrial services may change or address telephone number or the contact information. Should not be any offense to the police shall avoid all contact with the victim, the victim's family, and the New Township school properties. She will report to pretrial services every week. She will report telephonically once every other week and in person once every other week. She will refrain from possessing any firearms, charging offense with a dangerous weapon. She will refrain from the test use of alcohol and multiple use of narcotic drugs or controlled dangerous substances. The licensed medical practitioner reports not ordering a task evaluation. There wasn't any information with regard to the state's presentation of the investigation of probable cause with regard to substance abuse. I'm not going to order that she maintain or actively seek employment since these charges are specifically related to suspension of her ability to be a teacher going forward. She will, however, undergo a mental health evaluation and comply with any and all recommendations that come out of that evaluation or any recommended treatment going forward. Any recommended treatment going forward will be considered an order of the court as well, so if failure to comply with treatment is failure to comply with pretrial release conditions. She must notify the court immediately in writing if she detained in jail or prison or otherwise cannot incur full proceedings. If she fails to appear Superior Court proceeding is arrested in another state of jurisdiction, she agrees to waive all rights to extradition process by the demanding state or this state with regard to extradition law and any failure to appeal violation of the condition of release or restraining order or condition of new crime. And result in the issuance of a warrant or arrest, increasing the restrictive conditions, revocation for release, forfeiture, and monetary penalty, possible detention. Ms. Bailey, anything else that the state wants the court to consider before we leave this matter?
Your Judge, thank you.
Thank you, Ms. Bailey. Mr. Thompson?
No, thank you, Your Honor.
Ms. Karen, you will receive court order that you all these parameters that I have just placed on you. Trust based on your attorney's representations to the court that you understand the severity of the conversation that we're having right now, the severity of the charges, and why the community as a whole would be concerned about this court's decision by putting considerable restrictions in terms of your ability to be released, and those restrictions must be complied with exactly and precisely. And any failure to comply with those, even if minor or slight from your perspective, I guarantee you will result in an application from the state to point out whatever that violation was and ask the court to reconsider your release status, and more than likely ask you to be taken back into custody. And you could be taken back into custody at least temporarily before the hearing is held, just as you were in this instance. When you are released, I want you to contact pretrial services of Cleveland County. You need to find out who you're supposed to report to and when they want you to report, and then make arrangements as soon as possible for the mental health evaluation. Provide that information to Mr. Helmsley, Mr. Helmsley can provide it to the state, so the state is satisfied that that schedule is going forward, and then we'll deal with any issues going forward with regard to any recommendations that that evaluation. And in the meantime, if you have any family court cases between now and February 25th, let's appear for those, and you'll be back here on February 25th for court. Your matter is complete. You release consistent with that order.
Thank you, Your Honor.
Mr. Miller, do you have anything else? Are you willing, Mr. Wolf? Go ahead, Mr. Karen.
Sorry. Mr. Pumpy, is your other matter ready? Sure, it is. We can do that now if we want to. Mr. State.